Morning, everybody. Thank you for joining. Today's webinar is all about limitation and insolvency claims. We kind of chose this topic because I think it's something that can be quite complex in insolvency situations, and also a general refresher never does anyone, including me, any harm. So just to introduce us both, for those of you who don't know me, I am an Associate Director at Manolete, joined in May 2025, primarily covering the Midlands region. I've now got 26 years experience. I'm feeling very old and very sorry for myself in contentious and non-contentious insolvency law. And I do quite a lot of speaking, as quite a lot of you already know. And then Raj is just a barrister, so don't really need to say anything more about Raj. No, I'm joking. So Raj's got broad commercial transfer practice. He's a barrister that I've used in the past, and Manolete uses quite a bit. Has acted in a number of major cases, and I didn't realise you used to be a solicitor. And then you went over to the dark side.
Yeah, my old life, yeah.
Yeah, and then you're also a scary deputy insolvency and companies court judge as well. I say that not because you're scary, but I find all judges scary. For somebody who decided to be a lawyer, going in front of a judge and actually speaking myself used to terrify me. So there we go. Right, so for anyone who's joined these webinars before, I'd like them to be interactive, informal, relatively relaxed. If anyone's got any questions, comments, queries, you can either put something in the chat box, and I'll keep an eye on that, or raise your hand if you want to be vocal and speak in front of everybody. Most people tend to put something in the chat box, but please feel free to, because I like engagement, because it shows that we haven't bored everybody to tears. So that's my take on that. Right, so to kick off, we're kind of going to, the way we've structured this really is to talk about limitation generally, and then to kind of go into more specifics in terms of insolvency. And then we've got some questions that have already been asked, which we're going to cover off at the end. But again, if anybody's got any additional questions, please feel free to raise them. So in terms of why limitation is relevant, and it's one of the first things that we at Manolete will look at when we're looking at inquiries that have come into us, is whether or not the limitation period has expired, whether it's coming up quite soon, or whether or not there's still quite a bit of time, because obviously that will impact on how we deal with things. If a claim is outside of the limitation period, then that is obviously a complete defence to that claim. There is an issue as to where the limitation kind of starts to run from, and we'll go into this in more detail because in insolvency the rules are a bit different anyway. But the general principle is that, what have I done? Is that the limitation either runs from the date that the cause of action accrues, or from the date that that cause of action is discovered, because obviously sometimes things aren't discovered till a lot later. I guess a prime example of that, actually, if anybody saw the news this morning, is the Johnson & Johnson case about the baby powder, and whether or not baby powder used by Johnson & Johnson in the kind of 1970s, 1980s contained asbestos and has caused cancer in people. So that's quite topical at the moment, and obviously that's what we would, I guess, would kind of call latent damage, because it's something that hasn't come to the fore until significantly after that product was used. I mean, I guess in some it's like 30, 40 years. So quite a good example really on a topical basis. For reasons which always confuse me, you normally exclude the day on which the cause of action accrued, and you start counting from the day after, unless the claim accrues at midnight. So, and I remember as a trainee, the law changing on, I think it was the 1st of September 1999, show you my age, where the law changed about whether pensions vested in the trustee or whether they remained with the bankrupt, and we had a bankruptcy that started on that date, and so there was a big kind of backwards and forwards about whether or not we'd kind of fallen inside or outside of that particular period, and actually who the pension who the pension vested in. It's weird, some of these things that stick in your mind. And then the claim is brought when the court receives the claim form, which isn't always the date that the court issues the claim form. So quite often that's referred to as kind of, passing the court steps. Once the claim actually reaches the court and it's received by the relevant office, that's when the claim is brought. But obviously it may take the court some time, particularly at the moment, to actually then issue that claim. So I'm now going to pass over to Raj, who's going to talk to you about limitation periods more generally.
Right. Well, thanks very much, Rachel, and good morning, everyone. I was planning just to start with a reminder of some general points about limitation for the purpose of this session, just because I'm mindful that we have a mixed audience of insolvency professionals here. So with that, I thought I'd kick off with some general points. I may end up doing the Chris Whitty next slide, please, which I'm about to do, Rachel. Just to move on to slide 7. Thank you. So yeah, just 5 general points to make. I mean, a point that's not on here is that in most cases, limitation is not an issue. But what I would say is that if limitation has become a problem, then it's usually fatal. So if it's an issue, it's a big issue. So the whole purpose of this is to really anticipate these problems, of course. I mean, just 5 general points to mention. The first is there's no specific definition in law as to what a limitation period is. But a good working definition is this one. It's any provision which specifies a time limit within which legal proceedings of a particular kind must be brought. And I think that's quite helpful. The second point, just to mention the rationale. So why do we have limitation periods? Well, the courts typically have given 3 reasons. The first is that it's unfair. It's considered unfair for a defendant to have a claim hanging over them indefinitely. And it's designed to bring an element of finality as regards enforcement of legal rights. Secondly, more practically, the longer the time since the claim arose, the harder it becomes at trial to prove the claim, because documents get destroyed, memories fade, and such like. And then thirdly, courts say that claimants need to act promptly when they have a claim. And so for those reasons, the courts have developed over centuries the principle of limitation. And it's important to remember that limitation is entirely a creation of statute in law. And the first Limitation Act stretches back to 1623, but the law is now contained in the 1980 Limitation Act. Fourth, and I suppose these are the 2 key points by way of preliminary, is that different types of claims have different limitation periods. So part 1 of the 1980 Limitation Act identifies over 40 different types of claim. And in respect of each one, there's a specific period that applies. So you have periods running from 1 year up to 60 years. So a claim, for example, for tort needs to be brought within 6 years from the date on which the cause of action accrued, whereas one for defamation will be a year from the date of the cause of action accruing. And it's important to note that within this, insolvency claims are not specifically mentioned within the Limitation Act. So we have to look to case law to help explain what period applies in which to which claim. And then just finally, the key concept when you're talking about limitation periods is the cause of action. And by that we mean the combination of facts which gives rise to the right to bring a legal claim. And lawyers talk about when the cause of action accrues or arises, and that's the moment when all the necessary elements of the claim have been established. And that crucially differs between claims. So for example, claim for negligence, the cause of action isn't complete until you can show some damage, some loss. Whereas a claim for breach of contract, you don't need to show loss for the cause of action to accrue. You just need to show the contract has been breached. And what that shows us is that sometimes limitation decides what claims you need to bring, because some claims are out of time and some claims are within time. So turning on to the next slide, whenever we approach question of limitation, we have to think of 4 questions. So the first one is, what is the cause of action? So is it a claim for breach of duty against a director? Is it a section 423 claim? Secondly, how long is the limitation period? Thirdly, when does time start to run? And then finally, should the ordinary time period be postponed? And I was going to really focus on the last of those today. So moving on to question 1 and question 2, I thought I could deal with these two together, which is how long the basic or ordinary limitation period is. And you can see there some of the usual periods that are given for cause of action in the Limitation Act. So, for example, an action founded on tort can't be brought after the end of 6 years from the date on which the cause of action accrued. A normal contract is 6 years, but if it's signed under deed, then it's under seal, it's 12 years. Breach of trust, there's no limitation period if the claim is for fraudulent breach of trust involving the trustee or recovery of trust property from a trustee, and that's very useful against directors, or it's 6 years for any other breach of trust. And as I've said, there's nothing in the Limitation Act that specifically provides limitation periods for trustee in bankruptcy or for liquidators or other office holders making claims. And Rachel's going to touch upon that a bit later. But this does show that you really need to consider very, very carefully with your lawyers what the legal claim is and being able to craft a claim that matches the facts that you've got. So, for example, a DLA claim, that could be a debt claim, but it could also be a breach of trust claim. And there are circumstances when that would be advantageous. But of course, it all depends on the facts. So turning to the next slide, which is when does time start to run? And we can move on. Yes, thank you. So what we mean by this is when are all the elements of the claim made out? I'm afraid this is just not as straightforward as it probably should be, and it can throw up some trip hazards for both claimants and defendants. So as I said, it's normally time runs when all the elements of the cause of action are in place, but just a couple of quirks to mention on this. So the first one is a potential trip for directors and a bonus for office holders, which is DLA claims against directors. You have to first look at the terms of the DLA. Usually there isn't one, and it's not uncommon, of course, for the parties to enter into informal loan arrangements. So in the absence of any specific term, then generally the court's likely to decide that the limitation period runs from the date of any written demand, as opposed to the date of the loan itself. And so the debtor, the director, can't assume that the loan becomes statute barred after 6 years automatically, because the cause of action may not have accrued if no written demand's been made. But similarly, a demand needs to be made before you issue your claim. So the timing of that needs to be borne in mind, particularly for office holders who are assigning claims. If they've made a demand years ago, and they're assigning much later, then that needs to be very much in everybody's mind. The second potential trip is something which Rachel mentioned, which is the midnight deadline cases. And so this comes from most recently a decision of the Supreme Court, Matthew and Sedman, in 2021. And in that case, payment was due by midnight on a particular day. The Supreme Court found that the claim had been brought 1 day out of time and was time barred because the limitation period in a midnight deadline case, as Rachel has said, includes the day which follows the expiry of the deadline. So what this means is that where the cause of action accrues at midnight, the day starting at midnight and 1 minute past midnight, counts when calculating the limitation period. Now, in contrast, when the cause of action accrues during the day, so say, for example, a payment needs to be made by 4 p.m. on Tuesday, then the day on which the cause of action accrues is not included. It's not counted when calculating limitations. And that's being described by some commentators as a bizarre situation which transcends practical reality. But what I would say is you don't want to be on the wrong side of that in that sort of case, of course. And just another, before we leave this slide, just another quirk is, for example, office holder claims, and in particular, I'm thinking of section 213, 214, and the authorities really haven't distinguished between the date on which the company goes into liquidation and the date on which a liquidator is appointed. So there's an argument that actually it's the later date in the case of a voluntary liquidation. But I would say it's always safest for applicants, for office holders, to assume it's the earlier date, just to be safe. So turning on to my sort of fourth point, which was, should the ordinary position time period be postponed or delayed? And this is where, unfortunately, this is where often huge difficulties can arise. And there are a few ways in which the usual time period is postponed or even excluded outside the Limitation Act. So an example of that is recently with the breathing space moratorium and mental health crisis moratorium in bankruptcy matters. So that's the debt respite scheme regulations 2020. And what that does is it extends an expiring limitation period to 8 weeks. After a moratorium that's been given by the regulations. And the idea is to give a breathing space to anyone with a problem debt or to someone having mental health crisis treatment. So all of that is outside the Limitation Act. But generally in civil matters and inside the Limitation Act 1980, one of the most important issues that arise, especially in insolvency cases, is Section 32 of the Insolvency Act. And what this provides on the slide is postponement of limitation in the case of fraud, concealment or mistake. So Section 32 provides where a period of limitation is prescribed by this Act, and either the action is based on the fraud of the defendant or any fact relevant to the plaintiff's right of action has been deliberately concealed from him by the defendant, or the action is for relief from the consequences of a mistake, the period of limitation shall not begin to run until the plaintiff has discovered the fraud, concealment or mistake, or could with reasonable diligence have discovered it. And then subparagraph 2, deliberate commission of a breach of duty in circumstances in which it is unlikely to be discovered for some time amounts to deliberate concealment of the facts involved in that breach of duty. So essentially, Section 32(1) allows you to delay the start of limitation in these cases. It has given rise to quite a lot of case law, and I just wanted to touch upon some of the more recent ones now. So the first recent case on postponement is the Bilter UK liquidation, Bilter UK Limited and Tradition Financial Services, a decision from earlier this year from the Supreme Court. And that was a Section 213 fraudulent trading and a dishonest assistance case. But essentially it was about Section 32(1)(a), which we've just seen. And briefly, the facts were 5 companies had gone into liquidation because of VAT liabilities caused by an MTIC fraud. 2 of the claimants had been struck off and dissolved for a substantial period, many, many years, before the companies were then restored to the company's register and then placed into liquidation. Now, Section 103(2) of the Companies Act 2006 provides that the general effect of an order by the court for restoration to the register is that the company is deemed to have continued in existence as if it had not been dissolved or struck off the register. Now, the companies issued claims against Tradition Financial Services, alleging it had dishonestly assisted their directors in breach of fiduciary duty by carrying on fraudulent trading. And the liquidators claimed that Tradition could be made liable to contribute to the company's assets under Section 213(2) of the Insolvency Act because it had knowingly been a party to the fraudulent trading. Now, the parties reached a confidential settlement, but a few points remained undecided, and those were sent to the court for determination. And so they were relatively narrow questions. But essentially on the Section 213 claim, the judge found that the liquidators' claims fell within Section 213, but the company's claim for dishonest assistance was time barred. Now, both Tradition Financial Services and the companies appealed, and it went all the way up to the Supreme Court. Now, what the company said was that for the purposes of Section 32 of the 1980 Act, they could not, with reasonable diligence, have discovered the fraud during the period of the company's dissolution, because during that period, they were deemed by Section 103(2) of the Companies Act to have been in existence, but in reality, they had no directors or anyone else who could have discovered the fraud. Now, what's relevant for us is that the Supreme Court held that where a restored company wishes to pursue a claim in fraud and to postpone limitation under Section 32, the burden of proof is on the company to show that if it had not been dissolved, then it could not, with reasonable diligence, have discovered the fraud. Now, what happened in this case was that the two companies had not advanced any evidential case on this particular issue, and the court found that they'd failed to discharge that burden. And the consequence was that their claims in dishonest assistance were time barred under the 1980 Act, even though the Section 213 claim had the potential to proceed. I think that's an important lesson on the need to think about limitation in advance, and also for your legal team to think about what needs to go into evidence, what needs to be pleaded specifically. So that was the first case on that slide. The second case I wanted just to mention was Granville Technology Group Limited, which is a decision from last year. Now, this was a commercial court decision, and it was essentially in the context of a claim for follow-on damages arising from the activities of a cartel fixing prices in the worldwide LCD panel market. But for our purposes, the relevant question that was asked was, I should say, the company was in administration at the time, and a question that was asked was what could be expected of a reasonably diligent IP, in that case the administrators, for the purposes of Section 32(1)(b) of the Limitation Act. Now, the context of the limitation question was that in 2009, it was reported in the press in the UK that the European Commission had issued a statement of objections about the defendants' conduct and about this cartel. And the defendants argued, and this was before the Commission published a decision about the cartel, and the defendants argued that time began to run before the Commission published its decision, when reports were given in the press. And so they argued that the claims were time barred on that basis. Now, that would have been correct had the claimants not been in liquidation, because the company directors could reasonably be expected to pay close attention to reports concerning their industry, and they could, with reasonable diligence, have learned of the cartel in 2009. But because the Limitation Act, the court found the Limitation Act and Section 32(1)(b) was in play, and if the court found that if a claimant was in administration when the facts concerning a cartel began to emerge, then Section 32(1)(b) didn't require that it be treated as if it were still trading. And so in determining whether, for the purposes of Section 32(1)(b), the claimants could, with reasonable diligence, have discovered the cartel when it was reported in the press, the question was, what could be expected of a reasonably diligent insolvency practitioner? And this is the interesting point. The court said that an administrator of a hopelessly insolvent company could not be expected to access foreign news media or follow the trade press after trading had ceased. But the position might be different if the administrators were continuing the company's business with a view to selling it as a going concern. But that wasn't the case in the Granville decision. So the court found that by operation of Section 32(1)(b), the claims were not time barred. Now, it's yet another, unfortunately, yet another issue that administrators need to be aware of if they're trading a company, that essentially limitation is continuing. And they need to be aware of obviously potential claims, and you know, the need to conduct diligence as to what's going on in the market. And then finally, I just wanted to talk about the Canada Square Operations and Potter decision, which is one, thank you, Rachel, which was from a Supreme Court decision in 2023. Now, I've set out the key dates on the slide here, but essentially this case concerns pension mis-selling, PPI, sorry, not pension, PPI mis-selling. And the background to this, just very briefly, is that Mrs. Potter took out a loan from Canada Square Operations, which at the time was known as Egg Banking PLC. So that was one of the very earliest internet banks in the late 90s, which many of us will remember. Now, Mrs. Potter obtained a loan from Egg in July 2006, the loan was on, agreement was Egg's pre-printed standard form, and it was a credit agreement within the Consumer Credit Act 1974. The amount borrowed by Mrs. Potter was £16,000 odd, and she paid a PPI premium of £3,800 odd. And the loan was payable over 54 months. Now, Egg was also an insurance intermediary. 95% of the premium was in fact the defendant's commission on the PPI policy, and the actual amount paid to the insurer from the premium was just £182. Now, Egg's mistake was that it didn't tell Mrs. Potter that it was receiving any commission. Mrs. Potter paid the loan off early on the 8th of March 2010, and she thought that was the end of the matter. But then there was a decision in November 2014, the Supreme Court, in a case called Plevin and Paragon Finance Limited, and that held that non-disclosure of a high commission charged to a borrower in these circumstances would make the relationship unfair within the meaning of Section 140A of the Consumer Credit Act. And the consequence of that is that the borrower is entitled to a remedy under Section 140B. So Mrs. Potter decided to complain to Canada Square that she'd been missold PPI, and she received compensation under a scheme established by the Financial Conduct Authority for PPI mis-selling. Again, you would think that's the end of the matter, but she consulted solicitors, and they'd issued proceedings in the county court in December 2018 seeking compensation. Now, the lender argued, that's Canada Square, argued Mrs. Potter's claim was time-barred under Section 9 of the Limitation Act, and this provides that an action to recover any sum recoverable by virtue of any enactment shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. So the question was, when did her cause of action accrue? Was it 2006 or was it 2010 when the loan payments were made? The claim was issued in 2018, so it was well outside the 6-year period. Mrs. Potter argued that Section 32(1)B applied and it postponed the start of the limitation period running. And she argued that the lender had deliberately concealed the fact and extent of the commission from her for the purposes of Section 32(1)B, and therefore the period of limitation didn't begin to run until she discovered that concealment. And as I say, the limitation point went all the way up to the Supreme Court before being sent back down to the county court. And the court decided the claim was not time barred because Section 32(1)B applied. The court explained that Section 32(1)B requires a fact relevant to the claimant's right of action. So in this case, it was the commission that was paid. Secondly, concealment of that fact by a positive act of concealment or by withholding the relevant information. So that's what happened here. Thirdly, an intention on the defendant's part to conceal that fact, which happened here. And the Supreme Court explained that there was no requirement for Section 32(1)B for the concealment to be in breach of either a legal or some other duty. So Mrs. Potter won that limitation point, but she said that the court said that under Section 32(2), it didn't apply. So you need to show for Section 32(2) that the defendant knew it was committing a breach of duty. Deliberate commission of a breach of duty does not include recklessness, nor do you need to show the defendant knew that he or it was facing a claim. So as I say, the court referred the matter back, decided the point of law, didn't decide the case, and referred the case back to the county court. And I imagine the case was settled pretty quickly after that. Thank you, Rachel.
Would help if I turn my mic back on, wouldn't it? Thanks, Raj. Okay, so I'm now going to talk about kind of the different types of insolvency claims that there are, and kind of the limitation, position in relation to them. So claims in insolvency really can be split into two kind of main categories. You have your claims which exist within the insolvency process, and they will be claims that will be pursued either by the office holder, not by the company, or by an assignee. And then you've got claims that existed prior to the insolvency process, which are claims that would be pursued by the office holder or by an assignee. If they're pursued by the office holder, then they're pursued in the name of the company. And as Raj has already said, kind of limitation and insolvency isn't specifically covered within the Limitation Act. So the limitation really in relation to insolvency is prescribed by the general law of limitation. It's also, I guess, governed by case law, and then whatever the provisions there may be in the Insolvency Act. And one of the things that we need to bear in mind in insolvency claims is the way I always view it really is that you have two limitation periods. You have your normal limitation period, I'll call it, which is your, say your 6 years as a base starting point. But you also have your look back or your twilight period. And for lots of insolvency actions, you actually have to be able to fall within both the look back period and the limitation period in order to be able to bring a claim. So whenever I think about limitation, you're always thinking about kind of it's a two-step process really. So just to kind of cover that in more detail, then, as I said, there's various claims that can be brought either by the office holder or the company or by an assignee, and many of those have a look back period. And the look back period, or the twilight period as it's sometimes called, is the period of time leading up to insolvency that a right of action can have accrued within. And that will differ quite often in insolvency depending on the category of defendant that you're looking at. So unfortunately in insolvency we like to make things complicated and a bit quirky. So you might have one cause of action, but you might have different look back periods depending on who the defendant is. And as I've already said, you've got to fall within the limitation period and the look back period in order to be able to kind of have a claim that's worthy of being pursued. So if we look at the limitation period first, in relation to what the limitation period is, as Raj says, that you have to look at what remedy you're looking to get. So if you've got a monetary claim, then quite often the time limit will be 6 years. But if you're pursuing the return of property, for example, then the limitation period can be 12 years. So again, that's kind of another quirk. Not only do we have different limitation periods for different claims within insolvency, we also have different limitation periods depending on what type of insolvency process you're dealing with. So for example, if you're looking at a bankruptcy and the use it or lose it provision, then that's normally 3 days from the date of bankruptcy, for which that claim needs to be brought. If you're looking at the claim on the bond of a prior appointment holder, then you've normally got 2 years. If you're looking at breach of duty, if you go back to what Raj was saying earlier, that sometimes framing an action as a breach of duty claim actually is more advantageous, particularly in circumstances when you're talking about limitation, because in certain circumstances in relation to breach of duty, you can disapply the limitation period. So the general principle is that if you are bringing an action against a director of a company who is viewed as a trustee of the company, if the director has personally benefited, then you can disapply the limitation period because he's viewed as being a trustee effectively who's abused his position and taken company assets for his own benefit. And that disapplication of the limitation period also extends slightly further. So in the case of Burden and Fielding, that was a case where the company moved assets from one company controlled by the director to another company controlled by the director. And the director said, well, actually, the claim hasn't been brought within 6 years, so therefore the limitation period doesn't apply. And the court said, no, you have personally benefited because you control or have a controlling interest in that company that the property was transferred into. So that ability to disapply the limitation period for breach of duty is quite useful. It's very strong and often will lead to cases being framed more as a breach of duty claim rather than a claim under a specific section of the Insolvency Act. And I think probably a good recent example of that is the BHS case, where you had fraudulent trading, which you very much bring under, the relevant sections in the Insolvency Act. But then we had what's being viewed, I guess, as like a new claim, but it isn't really, is the misfeasant trading. And actually that's a breach of duty claim. And what that enabled to was obviously one, a disapplication of the limitation period for the time limit for bringing the claim, but also enabled the court to actually find the directors liable from an earlier point in time. So breach of duty claims have numerous benefits in relation to limitation, not just the actual limitation period for bringing the claim in the first place. So then moving on to kind of the look back and twilight period. So again, it's different for different types of claims, and we'd be here all day if I covered kind of every single claim that there would be. But just to highlight some where it is a bit quirky is a preference. So this look back period is different depending on the identity of the defendant. So if you're looking at a preference that's taken place to a connected party, then that's a 2-year look back period. But if it's an unconnected party, then it's only 6 months. Invalid floating charge, throwing that in again, because it's a little bit quirky. If it's to a connected party, it's 2 years. But if it's to an unconnected party, it's 1 year. So it just kind of, gives a bit of an example of all of the relevant differences, which again leads back to Raj's point from earlier, is that really when you're dealing with insolvency claims, you really need to nail down with your legal team really early on, what the different limitation periods are, because you could have one act that you are complaining about within an insolvency situation, but it could have lots of different limitation periods depending on who it is that you're actually kind of pursuing. So then looking at whether or not limitation periods actually stop running. So when a company goes into liquidation, the time stops running. So a claim against a company that isn't time barred when a company goes into liquidation remains live. What this doesn't do is stop limitation periods running for claims that the company is going to bring. And I have seen sometimes people argue that limitation that limitation period kind of works both for the company's benefit as well, but unfortunately it doesn't. In terms of who is worth suing, then you have to look at the joint liability. Is there more than one person that could be liable for that? Is that potential liability something that can be guaranteed? And is there a condition precedent that actually a judgment has got to be obtained? And then in an administration, again, we have this moratorium which stops people bringing action against the company. But what it doesn't do is automatically suspend, limitation periods in respect of any action that the company may be looking to take. So again, it's kind of something that needs to look out for. I've seen someone put a question in the chat box, so we'll come back to that. We'll just finish these bits off first. So in terms of approaching limitation, if you're approaching limitation, what are your options? I'm going to say this, obviously, pick up the phone to someone at Manolete, because we can act really quickly and we can help you with your limitation problems. But the main ones are issuing protective proceedings. The risk with protective proceedings really is that you probably haven't been able to comply with the pre-action protocols, which will set out various time limits, of things that you need to do prior to issuing proceedings. So what would normally happen is protective proceedings would be issued, and then you'd apply for a stay whilst you then kind of did all of the pre-action, protocol stuff. Another situation where that often is used is if you're coming up to the end of the 3-year use it or lose it provision within bankruptcy, because you have to take a step within 3 years, one of which is issuing proceedings. So sometimes proceedings will be issued and then there'll be an immediate stay agreed whilst the parties then try and negotiate the position, but they're issuing proceedings just purely to protect that right of action. Or you can enter into a standstill agreement, which effectively, stays that limitation period for whatever period of time you agree within a standstill agreement. So they're kind of the 3 main kind of things to think about when looking at approaching limitation. So in terms of questions that we have already been asked, and then I'll come back to that question in the chat box. Raj, I don't know if you want to pitch in on any of these, but yeah. So the first question is, what are the limitation periods for office holder claims if there has been a lack of cooperation, non-disclosure, misrepresentation or fraud? Obviously, if the office holder has been fraudulent or dishonest, then there may be a claim under the bond, which normally is 2 years from the date that the office holder ceased to act. But again, there are lots of changes happening with bonds at the moment, so you'd need to go back and just double check that depending on when you were looking at the particular cause of action. And then obviously action can be taken against office holders, under provisions within the Insolvency Act for misfeasance or say a breach of duty claim effectively. So again, the limitation period for that, I would say, would be 6 years from the date of that breach of duty act. Raj, I don't know if you've got any comments on that.
Yeah, I mean, just with those questions. I mean, on the first one, absolutely, there is that would engage Section 32. So lack of cooperation, non-disclosure, misrepresentation, or fraud. If you look at it on the part of the defendant, then that would certainly kick it in. What I would just say about that is one has to be really careful, because I often see insolvency practitioners engaged in a lot of correspondence with defendants, and it goes on and on and on, and limitation is being run down. And I mean, the bottom line is that there is a point at which you have to issue a claim, and so a view has to be taken as to whether there's a relevant limitation period kicking in. So lack of cooperation isn't always isn't a firm answer. Non-disclosure, misrep, fraud obviously will be, but again, if you discovered the fraud, if you're aware of it, then time's probably running, and you should assume that's the case. Yeah.
I think I guess the other point is, so there's two ways of looking at it. It's claims against office holders, and then claims that the office holders are looking to bring. And I suppose the other point to make in relation to particularly for the breach of duty claims is that the time limit for those breach of duty claims doesn't run from the date of insolvency. It runs from the date of the breach of duty. So there may be lots of different dates that limitation starts to run from. So when you're looking at cooperation or lack of cooperation, then the longer you engage in that correspondence, you might find that you started off with 20 breaches of duty, and actually by the time you're ready to go, some of those have already kind of dropped off the other end, unless you can disapply the limitation period. And I think that's a point that quite often gets missed in terms of, breach of duty. It's not the date of liquidation or administration, it's the date that act happened. So it may be that you're quite up against limitation by the time you even get appointed on a case.
Yeah.
And I guess we've kind of answered question 2 within answering question 1, which is limitation on claims against insolvency practitioners.
Yeah,
that's just one. Yeah,
just on the third one, I mean, on the question of when limitation runs for claim under Section 43, I mean, it's generally considered it's from the date of a bankruptcy order, because the claim is not available before then. So it potentially obviously you can look back almost indefinitely. So it's a very powerful claim. But yeah, the limitation for that is it starts from the date of the bankruptcy order.
Yeah. And that's something with Section 43, I think, again, that sometimes gets not missed, but it isn't kind of recognised as much, is that in terms of the look back period, you can go back, as far as is needed. The test is whether or not, when you were making that decision, you were trying to put assets beyond the reach of creditors. And a classic example of that always is the traditional law firms, which was partners would make a decision: do I put all of my assets into my wife's name and risk a divorce and losing a lot of my assets, but against the risk of, well, if something happens to the firm and those assets get called upon, I've lost those, I've lost those assets. And that was always perceived as there could be a potential Section 43 action there, because you're making that decision in order to try and avoid losing those assets in the situation that an insolvency occurs, and therefore you have creditors. Which obviously then is different to the limitation period moving forward in terms of how long you've got to bring how long you've got to bring the claim. So I think quite often people say there's no limitation period for claims under Section 43. What, do they mean there's no limitation period, or is it actually more there is no look back period restriction? Just a thought on it anyway. Right, we've had 2 questions put in the chat box. So the first one is, what's the authority for the 12 years for the return of property? I don't know it off the top of my head. Raj, do you?
Section 8 of the Limitation Act 1980.
There you go.
So that's how you get depending on the context, but for example, section 238 a section 43 claim, so it can be characterized as a claim for recovery of money or a claim for recovery of property. And if it's property, then it's generally section 8. If it's and so it's a specialty, it's 12 years. So if you have sorry.
So if you have a transaction at an undervalued claim, say, company has moved an asset for less than value, if you framed and then that recipient still owns that property, obviously there's 2 things that you could claim there, right? Is either the value of the property, which I guess is your monetary claim, which would be 6 years.
Yes.
But if you're actually then asking the court to put the property back into the existing, the insolvent company, so that the transaction never took place, you're restoring the position to what it would have been by actually moving title of the property back, then that would be 12 years.
Yes, that's right. I mean, often there isn't a choice. Often the property's disappeared. But if the property's sitting there, then there's there are many reasons why you'd go for it. I mean, one of them is because of limitation, but having the property is often better. It's but yes, that's absolutely right, and that's where the 12 years comes from. Exactly.
Yeah. Okay. And then the other question, I think this is definitely a question for you, Raj.
Goodness me. That's a difficult one. I want to thank Ali for that question.
Yeah.
I mean, not.
I sense he's sitting there giggling away in the background.
Yeah, I'm sure he is. I'll have to have a word with him. Shall I read it out? Do you have a feel for the impending Supreme Court decision in the Hutt Group? So the Hutt Group is THG PLC. It's a Zedra Trust claim. Zedra Trust Company, Jersey Limited case, whether it's likely to shed some light on Section 43 limitation periods, given that THG is about a Section 994 petition, but could be analogous because it concerns the limitation period in a statutory claim where no period is specified, non-binding, I guess, of course. Well, I mean, look, I don't have a feel for it to answer the specific question because I'm not involved in the case. I think Paul Chasty is one of the Silks who's dealing with that. And also Lance Ashcroft and some others. So unfortunately, I'm not involved in that case, but I absolutely agree with that. It's going to be really interesting to see what happens because the Supreme Court has a chance to just really clarify that, and particularly as regards Section 994 claims. So unfortunately, I feel it's going to be a wait and see on that one.
Can you just explain for those of us like me that don't know, what's the actual case about?
So it was, I mean, fundamentally, what happened in that case was the Court of Appeal held that they weren't bound by an earlier Court of Appeal decision in a case called Bailey, which was in 2021, I think it was, and that limitation periods do apply to unfair prejudice petitions under Section 994. So that's contrary to the long held wisdom. And then the limitation period is 12 years under Section 8 of the Limitation Act, unless the claim is for compensation for money, when it's 6 years. So essentially the point has been appealed to Supreme Court because really there isn't any recent authority on the point. But we'll have to just see what decision the Supreme Court makes. I mean, I know, as I say, I know the Chancery Bar conference earlier this year, Paul Chasty was sort of running explaining what he thought was going to happen, but I think none of us really know. Yeah,
but that's also why it could be analogous, because in insolvency we don't have kind of set defined limitation periods kind of specifically set out. Yeah,
it's absolutely. I mean. if I had to guess, I would say that I don't think the Supreme Court's going to change anything on our understanding of the difference between Section 8 and Section 9, because I mean, this is my guess, but the starting point, the problem is that there's nothing in the Limitation Act which relates to insolvency claims, and therefore there's a fallback on Section 8 and Section 9, because essentially it's a statutory claim. It's a time limit prescribed by statute, or a claim prescribed by statute. So I think they will still fall by that. Back to that, I can't see how a court can give much more guidance other than saying essentially, well, it's up to the court seeing the particular claim to decide how it should be characterized. But that's probably doing a bit of a disservice to counsel in the THG case, because I'm sure they had far more complicated arguments than that. But I suspect it's not going to change the dial massively. But who knows?
Okay. And then we've had another question. If I was appointed on the 1st of January 2020 and brought a Section 423 claim, which is structured as a debt claim, I take it I have 6 years to get on and bring this, i.e. until the 1st of January 2026. So I think we need to assume on that one that the date of insolvency and the date of appointment are the same date, just to make it easy.
Absolutely. I mean, look, if it's a Section 423 claim, then yes. If it is a Section 423, you say it's structured as a debt claim. That makes me slightly. I just want to nail that one down, and just make sure it's not actually a debt claim. But yes, in principle, I mean, that would be the purpose of framing it as Section 423. I mean, let's say if it's a debt claim, then I'm guessing a demand has already been made, which means you'd be out of time, which is why you're running down that particular route. But yes, in principle, that would be what you should be working towards. So you'd want to be getting, the claim issued.
Or alternatively, if it's a debt claim and it's against a director, then you may be able to frame it as a breach of duty claim and disapply the limitation period and get around it that way.
Yeah, but I mean, it's another example of just, to avoid complexities, because the more complexities there are, more uncertainty there is, the easier it is for parties to raise defences. And then suddenly what should be a relatively straightforward claim becomes, has risk attached to it. And so, yeah, I mean, if there's 3-4 months, or 2-3 months, to get something out, then I'd be working to the earliest time period you've got.
Yeah. Okay. Well, thanks everyone for your input and the questions. I mean, our details are relatively easy to find if you don't have them already, but I shall put them on the next slide. So if you do have any other questions or you want to chat anything through, then you can contact either of us. Raj, I'm offering your services for that purpose as well, so hopefully that's all right.
Absolutely.
And then, as I said before, we'll be running more of these webinars. So if anybody's got any particular topics that you think may be of interest, please feel free to drop me a line and we can look at those. I think the next one that I'm planning will be in January, hopefully, which will be kind of dealing more with issues of compliance, and we might run that more as a bit of a Q&A session. So again, if anybody's got any particular thoughts or queries or aspects of compliance and insolvency that you might want to have covered, then again, please feel free to drop me a line and we'll see what we can do. So if there are no other questions, then I just leave to say, Raj, thank you very much for joining me, and thank you everybody for attending, and hope to see you all soon.
Great. Thanks very much.